This conference will now be recorded.
Yes, Ms. Siebert.
Kurt Hilbert is attending, but for some reason his audio is not coming through. So just FYI on that.
That's fine. That's fine. I just want to make sure that who's on the line. I'm sure y'all want to make sure you know who's on the line too. I mean, might be somebody from the. You never know.
Your Honor, this is Andrew Johndal, also on the line for petitioners.
Okay, great. All right. Well, I know everybody's running and gunning, so let me give you my agenda very briefly, and then we can add things to it. And I'll just say what I want to talk about. I want to talk about the status on the federal case. I understand that I believe a stay was entered in the Cawthorn litigation, but Mr. Bopp, I'd like to hear just whatever the status on that is from your perspective. I want to talk a little bit about, and these are the things that are pending we need to talk about and resolve. There's a motion to dismiss or stay. There is a motion about live streaming. There is the submissions that have been submitted. There's apparently are no stipulations. I want to talk about that. There's a motion to enforce the subpoena of Representative Greene. There is a motion on constitutional issues, which I'm not sure I understand. So I want to talk about that a little bit. And then there's a motion to quash or stay. Is there anything else that anyone's aware of that we need to put on our list for today? Mr. Bopp, I'll ask you first. Well, who's going to, Ms. Siebert, are you going to speak for the?
I am. Mr. Bopp is in an airport trying to get home, quite honestly, right now. And so
I hear you. So what's anything else for the list, Ms. Siebert?
And I may have just missed it. Did you mention the motion in limine that we filed today?
Yes, which is which I'm calling it the motion on. It's the motion in limine burden of proof, but that's the issue, and I have some thoughts on that I want to talk about.
We had also filed. I'm sorry, we had also filed a separate motion in limine regarding evidence, hearsay, and so forth as well.
Oh yeah. That in my heading, that I should say stipulations, or that really goes into the documents list that was tendered. That's the way I would. That's the way I understand, and I want to have some thoughts on that too.
No problem. Thank you.
So but that's the list, and again, I mean, I'm sure that other things may come up. So let's just work through our list. Again, I apologize that y'all aren't getting to see a portion of my magnificent collection of Japanese cloisonne, which is in my home office, aka my dining room. So you just get to look at a blank screen. But the first thing on the current status of the Judge Schoenberg's case, Ms. Siebert, I guess you could give me a status report on that, please. Have y'all gotten anything? Have we gotten anything?
We have not. We did have the hearing, which Mr. Bopp attended on Friday. And she did indicate during that hearing that she would be issuing an order and a ruling today, is my understanding, but that has not come through yet.
Okay, well, obviously anything we decide today is subject to what may happen in that case, and I know we all understand that. So, and then the next thing was somewhat related. And again, Ms. Siebert, perhaps you can bring me up to date. As I understand, I got a garbled message about something might have happened in the Cawthorn litigation, and the only thing I could find was apparently there was a denial of a stay in further proceedings, but an order with an expedited briefing schedule. Do you have an insight into what's going on to that?
I do. Okay. Yes. So the interveners, who were the challengers in the Cawthorn case, similar to the challengers here, filed in the district court a motion to intervene, which was denied. It's actually been denied twice. It was denied. The district court ruled. They filed for an emergency motion. The challengers filed for an emergency motion to stay in the Fourth Circuit. The Fourth Circuit denied that emergency motion to stay, but remanded the issue of intervention back to the district court. The district court then denied the intervention a second time. And the court, though, Fourth Circuit, has now ordered expedited briefing regarding both the denial of the intervention as well as their expedited appeal of the on the merits of the injunction. Of course, the Fourth Circuit will have to grant them intervention before they could reach the merits on appeal.
Yeah, right. Okay. So, but there's been no, well, the case is still on appeal is bottom line. Okay.
Correct.
Okay. All right. Well, thank you for that clarification because it's very difficult sometimes to figure out what's going on.
There are trains and automobiles involved here. So, yes.
Exactly. Okay. The next thing, let's talk about and I'm going to call this the motion to dismiss. I mean, it's in my mind, the motion to dismiss is distinct from the discussion about the stay, which I want to get to later. The motion to dismiss, I mean, I think I don't need to tell you folks how complicated a lot of the issues in this case are, nor how important they are. And given the current situation, my thinking is that absent, I mean, again, Judge Totenberg, whatever she decides, whenever she decides it, could change things completely. But my current thinking is that until someone says stop, we keep going. I also think, and this also I think will get into one of the other motions that are pending. Quite frankly, I'm going to not probably. My current thinking is to reserve ruling on the motion to dismiss until after the hearing, and I have an opportunity to basically assimilate everything. It's a little bit of a chicken and egg question, and again, given the time constraints we have, it's not realistic for me to really satisfactorily go through all of this without a significant delay in the proceeding, and I don't want to delay it. So that's my current plan on the motion to dismiss. On the live streaming motion, I see no reason not as double negatives. I'm going to permit it provided that it can be done in a fashion that's no more disruptive than what we would normally do for a video recording or any other thing. And it's not uncommon at all for us to have, I say not uncommon at all. There have been a number of occasions when OSA has hosted, television recordings, the media want to have somebody. We just want to make sure that it's not disruptive. And in that regard, and quite frankly, I'm going to, Mr. Caprero, who is, a lot younger than I am and therefore is inherently more competent to talk about issues of technology. What we want to make sure is whatever streaming we do is not disruptive and can be interrupted. So for instance, if we need to, stop, just like we would say to the court reporter to stop transcribing or to turn the cameras off, we want to be sure we can do that. We want to be able to do it without any kind of complexity or disruption. Subject to that, I'm going to allow live streaming. Now, this sort of is, Ms. Siebert and I we'll need to talk about this a little bit. This gets into the documents that are being tendered and the objections to the documents, which are in several places.
Mm-hmm.
And again, I mean, I guess who's Mr. Celli? Are you the point guy today for petitioners?
Yes, Your Honor, myself and Mr. Fine.
Okay, well, I will let y'all decide which respond, but and let me address this to Ms. Siebert. Ms. Siebert, I don't find the generalized objections helpful because I looked at the list and I was sort of overwhelmed. It's a long list. It's a lot of material. Some of it, I'm just looking at it, seeing if Ms. Greene has sent a tweet and it's not disputed, it's her tweet. I mean, I don't know what it says, but I don't know why those subject to general relevancy and other issues that might, but conceptually, I don't have a blanket sense of why they shouldn't be admitted. So what I would like to do on the documents that have been tendered is, and again, I know y'all got a lot going on and I'm not trying to be difficult and we can talk about timeframes, but basically I need for the respondent to go through and say, this is inadmissible because, and just saying because it's protected by the First Amendment is not satisfactory. I mean, if there's a statement out there, if you're saying it's the speech and debate clause, well, you got to show me where the speech and debate clause says that something either a Congress representative elect or a representative says something is not usable in what is a civil, action involving their credentials. I mean, I'm having said that, I'm going to make another observation, which is maybe dangerous. I think that the respondent has made this point effectively, that in order to prevail, the petitioner is going to have to show that, and don't get too hard on me on the words, but basically it's going to have to show that following the administration of her oath, that the respondent did something that was part of an insurrection. I'm going to deliberately be vague about what that means. I understand that from what's been said previously, that the respondent contests that the tragic events of January 6th, which are a tragedy. I mean, just any way you look at it, just tragic. I mean, but that whether that's an insurrection, and I understand that's a very legitimate question, because so those are observations about the evidence. Now, let me address another issue, which again, this is not a definitive ruling on the issue, but it would appear to me, I mean, again, these are hypotheticals, but if there are statements or things that the Representative Greene said after, prior to her taking the oath, they may be relevant, but they may be relevant and they may be admissible because they pertain to events that occurred subsequent to her taking of the oath. But if that's the only evidence, back to that, I think there things have to be proven that show that she participated in an insurrection from and after the undertaking of her oath. I think y'all all understand where I'm going. But so, I'm not sure that a campaign I'm not sure an article she posted on Facebook in 2018 is really something we need to be spending a lot of time on. So I hope that both sides will focus on, let's get it down to what we need to have in the record, and the corollary is let's not object on everything that we can object to on some technical ground. So where do we end up? I would like for the respondent to respond, basically take petitioner's submission list and give me an annotated set of objections for it. If you want to make an overall continuing objection, it's all hearsay, you can make that, but that's not going to get you very far with me. Unless it's just, again, I don't need to see a column by David Broder. It's got to be something that's germane to the case. So that's my thought on the documents. Now let me mention something else. And somebody mentioned stipulations. And Ms. Siebert, the petitioner's submissions indicate that there are no stipulations. So this is directed to Ms. Siebert. So Representative Greene will have to prove her qualifications if there are no stipulations. In other words, she will have to prove that she's over what is it, the Constitution, 25? I think it's 25. I love the fact
it is for the House of Representatives.
The 25-year-old was old in 1783. God, it makes you stutter, doesn't it? But I mean, do y'all really want her to prove that she is over 25 and that she lives in the district? And I guess I'll rephrase that, Mr. Celli or Ms. Siebert. How do you want to address that?
We can stipulate to that she is over 25 and lives in the district. We have no problem with that. To be quite honest with you, the stipulation of facts was sent to us yesterday fairly late while we were trying to get a bunch of other motions together. And so we just didn't dedicate a whole lot of time to it. I'm not trying to be unreasonable, but clearly there are lots of
I hear you. I just wanted to make sure. Okay, so and this is going to get to another, this is going to hit another issue when we get further down our list. And let's talk about the next thing I have is the motion to enforce subpoena. And And I understand lawyers make decisions that are important decisions about how to present their case. That's not my job to worry about. So the question is, though, and the issue of the subpoena, which has been served and which there's been a motion to quash. In terms of, I don't know, and then there's a motion to enforce. Well, let's talk about OSA subpoenas. I'm not a superior court. I'm not the federal district court. I'm an administrative law court. And we have limited sanction authority. And I certainly would not encourage anybody to run the risk of incurring a fine for not showing up. But I do not have the ability to, cite someone for a civil contempt and, say until you show up, I'm going to fine you $50,000 a day. Any enforcement of subpoena has to be beyond the fine. I can fine somebody, but any enforcement of a subpoena beyond that, I actually have to refer to superior court, which of course is, this case will probably be resolved, gone through all the appeals before that gets heard. So I don't know that I don't need, I guess, Mr. Ancelli, this is directed to you. I don't believe I need to enter an order enforcing the subpoena. What I need to do is rule on the petitioner's, the respondent's request to quash. On the quash, I do not see adequate reasons to quash it, given the exigent time frame and the exigencies of this case. Now, to Ms. Siebert and to Representative Greene's counsel, I don't want to be oppressive. I'm surprisingly flexible. I don't know where the vacation is, but if she wants, I would entertain. I'm not suggesting, but I would entertain she could appear virtually if we could work that out. I'm not trying to make it difficult, but I'm also not proposing that we would postpone the hearing. Ms. Siebert, would you like to say something on that?
Well, yeah, a couple of things on that, Judge Goudreau, and we appreciate you're not trying to be difficult. We understand that. And we do understand the exigencies here involved. However, we do have a couple of specific issues, and we have not raised the issue of appearing remotely has not been raised before. So clearly that would at least help some with the travel issue that Representative Greene would have. The second issue that has just popped up, really honestly, in the past 12 hours is Mr. Bopp is lead counsel. He will be arguing at the hearing. He is still stuck in DC. He has had now, I think, about 5 flights canceled. There may be a significant issue of him actually getting there. And that honestly has just happened in the past 12 hours. So it wasn't that we were trying to hide that in our mission to quash. This has just been a nightmare for him.
Well, I'm saying, well, is he stuck? Is he literally can't get on a plane? Or, what is there some other problem?
He is in DC and he is trying, and now he is scheduled right now to get home from DC tonight. I think sometime very, very late tonight. But again, he's been scheduled every day since Saturday to be home from DC, and the flights keep getting canceled.
There are thousands, Your Honor, this is Jim Bopp. There are thousands of delayed and canceled flights going on in the United States right now. I have been 3 days now the victim of that. And, my bag is in Indianapolis, got in Indianapolis this morning somehow. And I'm stuck here in DC again. I've already had a plane canceled because of delay, and they're very difficult to get. I am praying that I get home maybe midnight or 1 o'clock tonight from Boston. And so it's very, very difficult. And let me say one other thing, because I've talked to Representative Greene about this. We can't say everything about this, quote, vacation. We would be revealing personal information to her enemies, political enemies. So we are really handicapped in our ability to describe the truly, and I've been practicing 49 years. I don't, being candid is very important to me. And the extreme personal, and I put that in the motion, the word extreme, personal problems that this would create for her. And we are available Monday and Tuesday of next week. She is not in session in Congress. She planned to be in the district. And furthermore, Your Honor, I mean, we're throwing all sorts of stuff at you. I'm just trying to even think of the time frame to deal with individual objections to all of these exhibits. I mean, and doing what else? Preparing witnesses, doing all these things. I mean, this is, and it would allow us all to do this in a more orderly fashion and in a timely fashion, and in a fashion that's not. I mean, we've proposed other witnesses who know her whereabouts during the relevant time frame. What you could order written questions. I mean, there's lots of ways that are provided for under the rules to deal with this. But if we're going to have her appear, I'm just begging the court to consider it.
Well, first of all, you have my profound sympathies on the personal travel thing. Mr. Shelley, go ahead.
Yes. So to go back to Your Honor's original point, this, we don't view this as a debating society where we need a particular ruling in a particular format. The most important thing, the critical thing for our case is for Representative Greene to be available to testify. And we're prepared to move this off until next week. Now, in papers that were submitted a couple of hours ago, they suggested the 19th and the 20th. Of course, Your Honor's schedule is the most important. We're available the 19th. The 20th would be a bit of an issue with us. Now, Jim, you just mentioned the 18th. I would make myself available the 18th. Well, no, I can't. I'm sorry, I can't.
Yeah, I agree with you. If I said the 18th, I misspoke. I meant the 19th and 20th. If I leave on another Easter with my entire family at my house, I don't know what my wife is going to do.
Again, I'm not trying to punish the lawyers. I'm very
Your Honor,
well,
the thing here would be to do this on the 19th if Your Honor could make room in Your Honor's schedule. That's really the only issue.
Well, here's my challenge. I have another election case on Tuesday the 19th, which has interesting Georgia constitutional issues. What we would have to do was I would have to see if we could move that, which I could also, unfortunately, I am heading into a bunch of scheduled things. I could see, but is everybody available the 19th? Let's get that as the first question.
For the petitioners, we are, Your Honor. Mr.
Okay,
Fine.
So and respondents.
Okay, now, and then that begs the next question. Will the respondent be available on the 19th?
Yes, Your Honor.
Okay. Will the respondent, well, again, I can't, that's not my call. All right, here's what yes, Devin, are you on?
Yeah, yes, sir. Pardon me for interrupting. I just wanted to remind you, a gentle reminder, that on the 19th, we have Hutstetler versus Lewis at 10 a.m. So this would have to be well in the afternoon, which given the complexity of it.
Here's what I was, well, there were two possibilities I was thinking about. One possibility is we could see, we can ask the parties in that case whether they could be willing to maybe take a continuance for a few days and we can reschedule it and then start the morning of the 19th. The other choice would be we could start at noon on the 19th, and then we could, and I've got a couple of, we could start, it's not going to be efficient. I'll have to take some breaks and all. The best choice, I think, would be if we can move Huffstetler, Devin, but we'll need to check with the lawyers on that. But if everybody is agreeable to the 19th, I think what we should do, what I think we being Devin and Osa and I should do, we should reach out and see if the parties in that case could accommodate bumping it to the next day or something like that. I mean, again, I think the parties are all here, and I think that case is quite frankly, I think it's more of a legal question than a factual question. And so if y'all are agreeable, I will see if we can do that. If we can't do the 19th, then my next really open day is Friday, April the 22nd. I don't like waiting that long. Would the 22nd work if we had to do that as the backup?
I think I'm looking at Mr. Fine. He and I are going to be the trial counsel. It's not fabulous. We prefer the 19th. But if we had to, we could do it, Your Honor.
Ms. Stevenson, the 23rd, and Mr. Bob, would that work for you if we have to?
Yeah, and I'm sorry to jump in because I promised Melina that she would handle this, but given that.
Well, but you know your schedule.
Yeah, I know my schedule, and the answer is yes, I can make it work, and I'm sure it's same situation with Representative Greene. She's still in the district for a district work session.
Okay, but well, I mean, she would be. So would she be available or not be available on the 22nd?
She would be.
She would be. Okay. Well, why don't we do this? And actually, while we're talking, I mean, Devin, I think what we should do, here's what I'm going to see if we can do. I'm going to first see if we can swap the Huffstetler case and move that to the 22nd. You know, that might be, and if they're willing to do that, then we can just slide into the 19th, and that works beautifully. If they can't, then we will look at putting this case to the 22nd. So that's my next. We'll have to, and we will, let y'all know as soon as we can find out.
Thank you.
So.
Thank you very much, John.
Well, again, I know I can't imagine the gyrations y'all are all going through. All right, so we're going to look at the 19th or the 22nd. One of those 2 days will be the continued date. We've talked about the subpoena. The next thing I have is the motion on constitutional issues. Let me tell you what I thought Judge Totenberg was saying and what I think is right. But y'all tell me, y'all were there, I wasn't there. There are two kinds of constitutional questions. One is that a defense requires the judge to determine that something is unconstitutional. For instance, to the extent the motion to dismiss requests me to dismiss this matter because the whole scheme of voter challenges that is under our Georgia statute is unconstitutional under the federal statute, I can't make that rule. I'm not permitted to make a ruling that a statute is unconstitutional. However, the 14th Amendment is just one of many, many laws that govern us all. So to the extent that the question is a constitutional question, like whether the speech and debate clause means you can't admit this particular statement, that's a constitutional determination I can make. And so with that, that's my understanding of what I thought was said at Judge Totenberg's hearing. And what I would, let's do this. Why don't I ask Mr. Celli his perspective on this, and then either Mr. Bob or Ms. Siebert can respond. But I want to make sure I'm responding to what I think you're asking. Mr. Celli?
Your Honor, I would ask Mr. Sells to take the baton here. He was there and represented our clients.
Okay.
He's the better lawyer for this.
Oh, that's fine. Okay, Mr. Sells, you need to unmute Mr. Sells.
All right. Can you hear me?
I can. Thank you.
Yeah. So the position that we took, Judge, at the hearing before Judge Totenberg, is that we think that you do have the authority to rule on Ms. Greene's constitutional claims. And I think that if the Georgia General Assembly passed a patently unconstitutional statute, that either your oath of office or the Secretary's oath of office would require adherence to the federal Constitution over the dictates of Georgia law. And I don't know your oath of office and whatnot, but I certainly know the Secretary of State is bound to follow the United States Constitution.
Well, excuse me for interrupting, but I think that's exactly what I was trying to say, that to the extent I am being called upon to make a decision, for instance, again, I'll use my evidentiary argument, that someone presents that says, whatever the rules of evidence say in Georgia, the federal Constitution and due process require X. Okay. When we say something is unconstitutional, I think we're saying either that it's unconstitutional under the Georgia Constitution or it's unconstitutional under the federal Constitution. I think I would be able to make that decision. Okay, is that consistent with what you said?
It's absolutely consistent with what.
Okay, that's what I thought. So with that said, and I don't know who wants to respond for the respondent and the pending motion. I don't know if that's Ms. Siebert or Mr. Bopp or somebody else. Who needs to respond on that?
Well, I guess I would ask for some clarification then, because during the federal case, and again, we excerpted this from the transcript of the federal case, is that our position is that the petitioners during that federal argument were pretty clear that this court could rule on the constitutionality of the statute. Now, if they are saying something different now, or there's a nuance there that was not asserted during the oral argument on Friday, then that's something different. Our point with this motion was to clarify exactly what the extent, and to have your Honor rule on the extent of what your limits are as far as applying constitutionality is one thing. And I think that's how I would phrase what you're saying, versus making a ruling on the constitutionality of the statute itself. And I think when you get into questions like the burden shifting and the First Amendment rights and so forth that we have brought up under here, I think it becomes very difficult to apply that without considering the constitutionality of the underlying statute.
Well, I'm not sure I agree with you, Ms. Siebert. I mean, I see it this way, and again, it's been a long time, longer than I care to admit, that I've actually had to noodle through things like this.
Mm-hmm.
A long time. But, and from reading very hurriedly the filings, I think the only, let me back up. I shouldn't say the only. If the question, I believe, on the challenge to the validity of the current proceeding is, and y'all can correct me again, this is my vague recollection, but the notion would be the reason the proceeding cannot go forward would be it's unconstitutional for it to do so. The reason for it to be unconstitutional to do so would have to be some fundamental defect, which the federal courts, and which Judge Totenberg would have to say, this procedure is not adequate to preserve and protect the respondent's constitutional rights. Okay? I don't see, I mean, if you think of what I am really functioning as the administrative law judge, I am building the record and I'm making an initial decision, which is a recommendation to the Secretary of State, which if the Secretary of State adopts it, and if the respondent believes the decision is unsound on constitutional grounds, the respondent has appeal rights, which is, why God invented appellate courts to correct mistakes. So I think the issue is not, and I wasn't there, and I read, and needless to say, colloquy in a transcript is less than crystal clear on a lot of things. But I will say this, I do not believe I can declare the application, the current procedure and the applicability of the APA to this procedure is inherently unconstitutional. I can make findings. I can create and I want to say if the respondent wants to present evidence to say why this proceeding is unconstitutional, in order for that to be part of the record, I think the respondent is free to do that. And then that is what the respondent would take up in terms of the objections as it goes up the chain. I believe, and I'm giving you, again, folks, I'm giving you my current thoughts based on very hurried readings. But now that if we have it sounds like we're gonna have a little time. So it sounds like I can actually write an order on this. But that is what I think that we can do. And again, Ms. Siebert, as usual, I interrupted. I'm very interrupted. So do you have a follow-up question or points you want to make?
I think we would agree that this, and that's why we submitted this motion, is that we wanted a ruling on this, that you would not have the authority to rule on the constitutionality of the statute itself, which is
when you say
properly.
the statute itself, what are you talking about?
The constitutional claims that we have made, for instance, in federal court.
Wait a minute, that ain't answer my question.
Sorry.
What constitutional question that I can't rule on? I mean, you can't just say it's constitutional. The law of the land is the United States Constitution. We're all bound by it.
Of course.
But what I can't do is again, the way the procedure works is if your argument is that you need is that Judge Boudreaux, we want you to rule on the constitutionality of Georgia. Dominic, what's the statute we're under? I mean, you've got that handy.
101-2-5.
Yeah. Are you asking me to rule on the constitutionality of that statute, Ms. Siebert?
Correct, Your Honor, because again, we have asserted that the statute itself, the 21-2-5, violates the Constitution in several specific ways. First, that it is based upon a government investigation triggered by a challenger's mere belief, violates a First Amendment right. Second, that the burden shifting to the respondent is unconstitutional under the 14th Amendment. We have a constitutional problem with the Article 1, Section 5, that the House determines qualifications. And then also the Amnesty Act, which is not constitutional, but a federal law, has precluded the application of Section 3 to any current members of the House or any current candidates or members of the House currently. Those are our constitutional claims in front of the federal court. And our understanding of the petitioner's arguments, and again, if they want to clarify or this is not what they meant during an oral argument, then we can discuss that. But our understanding of what they argued in federal court on Friday was that you would have the power to decide those questions that have been raised. And so that's where we wanted to file this motion in order to gain clarity on that.
Okay, well, I want to thank you for that clarification, Ms. Siebert. But I want to hear from Mr. Sells a minute, but I have a thought on that I want to address as well. Mr. Sells, give me your take on that, please.
Right. So it sounds like what respondents' counsel are asking for is for you to generate evidence that they can then file in federal court, say, Mr. Sells was wrong, and so you've got to decide these questions, Judge. Our position, I think, is pretty clear, and it's consistent with your articulation of it. That if you were presented with, let's say, a Georgia statute that says that, let's see, 18-year-olds can run for Congress, right? That would be patently unconstitutional because the age minimum for Congress is in the Constitution. We don't think that it would be impossible for you or the Secretary to say, no, that doesn't work. But that is an extreme hypothetical.
Well, let's take your extreme hypothetical though. Let me tell you how I would have to. I mean, again, I'm giving you reactions. I mean, I'm still trying to. I mean, these are again pretty good brain tester questions. But I think procedurally, the way it would be done would be, I would take the record, I would make findings, and I would say, and we may be standing on, I mean, I think we may be talking about a technicality, but technicalities are important. If something like that, then I would say, okay, Mr. Smith, who wants to run for Congress, is 18, and that is clearly not permitted by the Constitution. The Georgia statute would appear to be in direct contravention of the federal Constitution. And here are the facts. But I can't say it's unconstitutional. I would have to say I would send it up, and that would be up to the Secretary of State.
Well, I think that's right. Probably right, Your Honor. I don't know what your oath of office is, but I know that the Secretary of State takes an oath to uphold the Constitution. And I personally have brought constitutional claims against Georgia statutes that were patently unconstitutional, and he did not defend them. And so the Secretary of State is not obligated to, defend Georgia statutes that are patently unconstitutional. And so that was our position in court last Friday.
Well, and again, you folks are a lot more knowledgeable. And again, I wasn't there. But my recollection is federal intervention is only appropriate if the constitutional rights cannot be adequately protected in the applicable state proceeding. And again, y'all can go to put me to school on that. But but the way I described it on the hypothetical that we're talking about is exactly that. I would say Mr. Jones is running. He's 18. The statute says he can run. The United States Constitution says you got to be 25. On its face, this is patently a violation of the Constitution. But I can't say it's ordered. I can't make the formality of then ordering that the statute is unconstitutional on its face. I would send it to the Secretary of State, who would then proceed accordingly. And it's just because, again, in a way, you got to remember what my role is. In effect, the OSA judge is a hearing officer. It's sort of like a special master. I can write up the report and I can give it to the judge, but it ain't the judge's decision until the judge makes the decision. So, and I may be speaking way beyond the boundaries, but Mr. Sells, is that consistent with what your understanding is?
Yes, and that's the point I made on Friday is that at the very least, the Secretary of State, faced with an unconstitutional statute, would have the power to act accordingly.
Well, and again, as I said, I mean, the Secretary of State can reverse me. I mean, I can make a decision and the Secretary of State can say, we don't agree, and then if you have a fight with the Secretary of State, you go up the chain. I mean, that's again, why we have appellate courts. So that's a long harangue And again, I haven't written the order yet, but that's my thinking on this issue at this point. And I will, since it looks like we're headed for either the 19th or the 22nd, I'll try to have it out before then.
Your Honor,
issue.
we think
Go ahead.
it's important that you note in any order that the Secretary of State could then reverse you and
Well,
act.
that believe me, that's why we call it, when you see the decision, it will be called initial decision as opposed to final decision. No, I mean, believe me, at OSA, we're very aware of that. We get reversed all the time by the agencies who have reviewed. I say all the time. We get reversed a significant small fraction of the time when they really disagree with what we conclude. So, but yeah, I can put that in there. And again, if y'all want to submit something additional on this point, since we've had this discussion, I will be happy to review it as part of the response on that motion. Okay. Now, and I think the good news is I think we're coming to the end of my list. I think what we've decided that we are going to stay the case until either the 19th or what do we say, the 22nd?
22nd.
Friday? Yeah.
Your Honor, may I be heard just very briefly on that scheduling matter?
Absolutely. Absolutely.
We have a witness who is on our witness list, Gerard Magliacca, and I've confirmed that he is available on the 19th, but during this call, when the date of the 22nd first came up, and I haven't been able to confirm his availability for the 22nd. So if it looks like we might need to be on the 22nd, that poses a complication, or it may pose a complication for us that we wouldn't be able to say by the end of this call. Okay.
One of the great things about an administrative law court is we can be flexible. So if we need to schedule him for a telephone, we can call the hearing, we can have a telephone or a virtual hearing. We will, and it's the same thing for Representative Greene. She has important business she has to attend to. And if she, for some reason, can't come to Atlanta that day but it works, we can look at virtual. Again, I'm a great believer in virtual testimony after the last 2 years. So I understand, and we will. I want to do the dead level. And the worst thing that happens is we adjourn the hearing until the next morning at 10 o'clock when the witness can be available or something like that. So I appreciate that. Let me know what other issues you have on that score. So okay, all right. Well, that's the end of my list. Do folks have other issues that we need to talk about today?
None for petition, Your Honor.
All right, who wants to go first? Ms. Siebert?
Sorry, Your Honor, didn't mean to interrupt you. We had submitted also a motion today regarding shifting of the burden of proof. From the hearing on Friday, there seemed to be some, confusion on that. Maybe not intentionally, but I wanted to see if we could discuss that. Yes,
thank you. I thought I had that on the list, but you're absolutely right. Here's what we and because I've talked to, I've gone over this issue with a couple of folks, and I think we all are within OSA. I think we're all in agreement that this is the right approach, and it's consistent with what we do. As someone said in one of the briefs, it's impossible to prove a negative. So it's impossible for Ms. Greene, Representative Greene, to prove a negative. So the burden on proving that there's been an insurrection, is going to be on the petitioners, and I will put that in order. The corollary of that is that the burden on Ms. Representative Greene has to prove that she's 25 and a resident and all that stuff. But I believe y'all have all stipulated to that. So I think, which is important because it's going to affect the way that the hearing will go. If the issues are stipulated as to everything except the 14th Amendment challenge, then I think the burden's on the petitioner to go forward first.
Your Honor,
and Mr. Chelly, I'm happy to listen. Let me hear back from you on that.
Sure. I mean, again, if there is one fixed principle in our presentation is that Marjorie Taylor Greene is the most important and essential and critical witness in the case. If it's our burden and we have to go first, obviously we want her to be live in person for the court to observe her demeanor and how she responds to our questions. But we will obviously seek to take her as a hostile witness. I can't imagine there'd be an objection to that.
Well, whether there's an objection or not, I know she would be a hostile witness. So, I mean, when I say you would call her on your case in chief, but it would be cross-examination. It would not be,
Exactly.
it would not be a case in chief. So, you know, now whether we do it I mean, I'm not going to say today that I will insist that it should be in person. If she's got to be in Washington or she's got to do something, you know, it's half a loaf is better than none. And I think you would, but you know, we will get the record fully developed.
Right. We are moving this case, Your Honor, to convenience her, and I think that's the right thing to do.
Okay.
We've been told by Mr. Bopp that she's going to be in the district, and it's appropriate that she be live in person.
Okay. Well, and I think one is always one's own best advocate, but that's my thought. So with that said, wait a minute, I'm getting a note from Devin. Okay, well, that's all right. We're fine. Okay, well, that's okay. Y'all apologize. I've got to let Mr. Hamilton go. Hold on. Okay.
Thank you, Your Honor.
Yeah, you're good. Thank you. All right. Well, I think we're almost done. What else? What else do we have on the list for today? Anything from petitioner, Mr. Shelley?
No, Your Honor. Mr. Fine, is there anything? Was there something? You're muted.
Mr. Fine, you need to unmute.
All right. Professor Magliocca has confirmed that he could come on the 22nd, although he would prefer the 19th.
Okay, that's again, this is a moving target. I appreciate the difficulties this presents. Everybody's doing the best they can. So we will work as, you know, we'll solve it one way or another. We'll figure out how to do it. Okay.
Thank you, Judge.
Here's what I plan to do today, folks. Excuse me. I'm going to do an order that will talk about pretty much everything we did today or we've talked about. It will be very summary because I don't need to repeat everything that I've said today. And I'll probably just do it in one order just so I can get it all in one place. And I'll try to get that done in the next few days so we can get it out. And when did I say, and Ms. Siebert, you probably made a note, when did I say that y'all needed to get me? And I think we got off on rescheduling the hearing. Did we set a time for when your responses on the petitioners?
We did not. That was on my list of follow-up questions for you.
Okay, well, let's assume the 19th. You know, Judge Totenberg could change all of this. You know, you never know.
Sure.
Let's see. Let me get the calendar. Well, let's assume the 19th. So, oh, darn it. No, hold on, go away. I did push the wrong button. There. Okay, there. Okay. So the 19th is a Tuesday. And today is Monday. Could the respondent have your enumerated objections by document and specific reason by the 14th? That gives you, by 5 o'clock on the 14th. It gives you 3 days.
That won't be a problem.
Okay.
Can I ask one follow-up question regarding
Yes,
that?
sir. Yes, ma'am.
It's fine. Broadly speaking, and this was part of our motion to eliminate, can we assume that you will apply the regular rules of evidence here?
I will apply the rules of evidence which pertain in OSA proceedings. And as I'm sure you know, I have extraordinary latitude.
You do, and that's why I wanted to.
I will be using the standards that apply to OSA, which are very broad. If it's, obviously if it's, I will listen to any specific objection, but, if there's a video that's from a reputable source of somebody bashing a policeman's head in, that has to be introduced to establish as an element of insurrection. I mean, it was broadcast on, internationally on 7 networks. I mean, I'm probably going to let it in if it's relevant, So, I mean, this is the most important thing about this hearing, which I'm sure you all agree with, is given the world we live in today, it is essential that people feel that the record is complete and the decision is transparent. And, especially when we are dealing with people who are seeking public office, they live in the public eye. So it's very difficult to say, oh, well, this shouldn't come in because of X, Y, or Z, Now, I'm giving you and Georgia has a very, very, very strong public policy of information being available in our proceedings. So, having said that, I don't need to see the baseball scores from 1918. So again, so let's be realistic about what we argue about. So anything else?
Fair enough. I thank you for that clarification.
Well, I mean, again, it's the good in the administrative courts. We are designed to get a lot of information very quickly without the benefit of discovery. Sure. It's different when you're in Superior Court, where you have detailed discovery provisions and all of this gets worked out before the hearing. But in administrative courts, you can't have it both ways. If you're gonna have a quick expedited hearing, we have to be prepared to move pretty quickly. And we're going to err on the side of over inclusion. I can tell you that. I mean, I'm going to err on the side of including it. And it may be totally worthless. And I've had people introduce nothing. If you want to put it in, I'll put it in. But I'm going to look at the weight of the evidence. But when in doubt, I'm going to let it in. So, all right. I appreciate everybody. Again, I apologize that I can see all y'all and y'all can't see me. I mean, I'm really sorry you can't see my collection of cloisonne. So.
Maybe next time.
Thank you.
All right, next time. All right, well, thank you all very much. Oh, did we? Oh, the 14th at 5 p.m. Thank you. Y'all have a great day.
You too. Take care. Thank you.
Take care. Bye-bye.
Bye.
Take care, Anna.